Information Sharing and Other Matters Amendment Bill, first reading.
Honourable Maurice Williamson.
I move that the Customs and Excise Joint Border Management Information Sharing and Other Matters Amendment Bill be now read a first time. Sir, at the appropriate time I intend to move that the Customs and Excise Joint Border Management Information Sharing and Other Matters Amendment Bill be considered by the Very Good Justice and Electoral Committee, that the committee report finally to the House on or before the 9th of December 2010, and that the committee have the authority to meet at any time when the House is sitting, except during oral questions, during an evening on a day in which there has been a sitting of the House, and on a Friday in a week in which there has been a sitting of the House despite Standing Orders 187 and 191B and C. Mr Speaker, the bill is an omnibus bill, and it amends both the Customs and Excise Act of 1996 and the Biosecurity Act of 1993. The bill makes important improvements that are required to support the sharing of information across border sector agencies. These amendments will ensure Customs and the Ministry of Agriculture and Forestry meet the government's priorities in relation to the delivery of the joint border management system and support effective collaboration at the border. It also provides for improvements in the effectiveness of customs law enforcement. These amendments will restore the level of effectiveness to the administrative penalty and the petty offence schemes that was intended when the Customs and Excise Bill was actually passed way back in 1996. And finally, the bill addresses emerging customs and border management issues and provides clarity to existing legislative provisions to improve administration of the Customs and Excise Act. So, sir, let me take you through the purpose of the bill. The bill contains three categories of amendments. First of all, amendments to provide for planned information sharing by Customs with the Ministry of Agriculture and Forestry, MAF, and across a range of other border agencies. Amendments to enhance the effectiveness of customs law enforcement mechanisms. And thirdly, 9 smaller amendments to clarify provisions within the Customs and Excise Act. Let me take the House through those three sections. The identification and management of border risks requires information to be accessed and shared by border agencies. The government has recently agreed to a $70 million funding for a joint border management system which will provide Customs and MAF access to collaborated information needed to identify risks at our border. The joint border management system is due to be tendered and system development will begin in early 2011. The current statutory provisions for information sharing allows for information to be shared, but only on a case-by-case basis. Sir, this is not sufficient to cover the quantity of information and the process for information sharing between Customs and MAF anymore. This bill contains amendments to the Customs and Excise Act and the Biosecurities Act that are necessary to support shared access to information by Customs and MAF under the new joint border management system. The amendments also provide a legal framework to support the interim information sharing projects between Customs and MAF until the joint border management system is fully established. Further, Customs is involved with a number of centres which operate jointly with staff with different agencies across the whole gamut, from Customs through MAF, through Immigration, Police, Defence and other agencies. These centres provide a mechanism for sharing staff and intelligence to ensure that risks are identified and effectively managed. The existing statutory provisions relating to such information sharing are, of course, unnecessarily complex. Given Customs' range of agency interrelationships and connections, amendments in the bill establish an information sharing framework that will enable Customs to manage access to and sharing of border information by relevant agencies. Mr Speaker, Customs' assessment of risk relies heavily on the quality and accuracy of the information provided by importers. The administrative penalty scheme that operates under the Customs and Excise Act is no longer providing a sufficient incentive for compliance by the importing community. The existing provisions relating to the petty offences regime are very limited in their scope and reflect the circumstances which applied when that Act was originally passed back in '96. Customs have identified amendments to restore the level of effectiveness intended when these schemes commenced. This second set of amendments will strengthen the administration penalty regime, which will increase the minimum penalties to be applied as administrative penalties, increase the maximum penalties that can be dealt with as administrative penalties, adapting the penalty regime to reflect the degree of culpability, because that's an important aspect to this, and to include in the estimation of revenue avoided the GST otherwise payable. Amendments will also extend the range of provisions which can be dealt with as minor offences under the petty offences regime. And, Sir, the bill also includes 9 amendments that are required to either clarify existing provisions or address new situations that have emerged since the Act was passed in '96. The amendments clarify licensing and excise liability requirements for biofuels and biofuel blends and reduce compliance costs for low-volume producers. The bill allows the use of reasonable force within certain customs-controlled areas to detain people or compel unauthorised persons to leave. It enables customs to prevent goods from entering New Zealand that have been designed, manufactured or adapted to facilitate a crime of dishonesty. For example, EFTPOS card skimming machines that were clearly being brought in for a crime of dishonesty. The customs were unable to stop that from happening. It creates, and this is my personal favourite, a specific offence for injuring or killing a customs dog. It brings it into line with police dog treatment. It enables goods that must be imported in multiple shipments to be managed as if they were a single shipment. It allows for making of regulations to define the point at which an export entry is deemed to have been made, defines when a postal article has been produced or delivered to a customs officer, provides the specific method for calculating the value of temporarily imported goods at the time of exportation. So, Mr Speaker, the bill amends in this. It enhances customs law enforcement, which is essential to ensure that the government can prevent the importing of drugs and precursors, other illegal activity at the border, and it contributes to the prosperity of our entire country. Mr Speaker, I commend the Customs and Excise Joint Border Management Information Sharing and Other Matters Amendment Bill to the House.